Good evening and welcome to Courts Today. I am Urvashi Chauhan and in this video we will cover some of the top legal updates of the day. From the Bombay High Court acquitting all 12 accused in the 7/11 Mumbai blast case to Supreme Court stay on release of Udaipur Files. Also included are updates on CLAT 2026, actor Shreyas Talpade's relief, custodial torture compensation, Byju's insolvency case and Supreme Court's remarks on the Samajwadi Party's office allotment. Watch till the end and please make sure to subscribe and hit the bell icon. In a major decision, the Bombay High Court has quashed and set aside judgment of a special Makoka court which had earlier sentenced 5 men to death and 7 others to life imprisonment for the deadly 7/11 Mumbai train blasts. On 11 July 2006, 7 pressure cooker bombs ripped through local trains on Mumbai's Western Railway line during peak evening hours, killing 189 people and injuring over 820. It was one of the deadliest terror attacks in the city's history. This led to a massive investigation and arrest of 13 men. Back in September 2015, the Special Court under Maharashtra Control of Organised Crime Act held 12 men guilty. 5 of them were given death penalty while 7 were sentenced to life imprisonment. But now, after hearing the appeals of both the state and the convicts for over 6 months, a special bench of Justices Anil Kilor and Sham Chandak of the Bombay High Court has ruled that the prosecution failed to prove its case beyond reasonable doubt. The High Court judgment comes nearly after 18 years of incarceration for the accused. A detailed copy of the verdict is still awaited, but this ruling has overturned all convictions in the case. One of the accused, Wahid Sheikh, had already been acquitted by the trial court, but only after spending 9 years in prison. Prominent senior advocate and former Orissa High Court Chief Justice Dr. S. Muralidhar had appeared for 2 of the live convicts and made powerful arguments before the High Court. He pointed out serious lapses in the investigation, media trials, and how the police had assumed guilt first rather than investigating with an open mind. He said that these men had lost 17 years of their lives behind bars without even a single day of release. And once acquitted, there was no real chance to rebuild their lives. Muralidhar also reminded the court that the stigma of being accused in a terror case affects not just the person, but their entire family. Children, parents, relatives who face lifelong social discrimination. The High Court's verdict gives relief to the 12 men but also opens up conversations around accountability, fair investigation, and justice delayed in our criminal justice system. In the next update, the central government today informed the Supreme Court that it has ordered 6 changes to the film Udaipur Files after reviewing revision petitions challenging its CBFC certificate. These include a detailed disclaimer, removal of specific dialogues and scenes, and character name changes. The Supreme Court has kept the movie's release on hold till Thursday, giving all parties time to file objections. In June 2022, a brutal murder in Udaipur shook the nation. Kanhaiya Lal, a tailor, was hackled to death in his shop, allegedly by 2 men named Mohammad Riaz and Mohammad Ghoz. Soon after the crime, the accused released a chilling video, claiming that the murder was a revenge for a social media post shared by Kanhaiya Lal, which they believed supported former BJP spokesperson Nupur Sharma following her controversial remarks about the Prophet. The investigation was taken over by the National Investigation Agency and some serious charges under Unlawful Activities Prevention Act and the Indian Penal Code were framed against the accused. The criminal trial is currently underway before a special NIA court in Jaipur. Meanwhile, the film titled Udaipur Files Kanhaiya Lal Tailor Murder, based on this incident, was slated for release. But its release triggered controversy. Multiple petitions, including the prominent Islamic clerk body Jamaat Ulema-e-Hind and its president, approached the Delhi High Court, raising concerns that the film was communal in nature and could incite unrest, especially since the trial was still pending. Last week, the Delhi High Court stayed the release of the movie and allowed the petitioners to approach the central government with a plea to reconsider the film's CBFC certificate. This matter then reached the Supreme Court. 2 petitions are being heard together in the top court, one by a person accused in the Kanhaiya Lal murder case who is opposing the film's release and another by the filmmakers who are challenging the Delhi High Court's stay. Today, the central government informed the court that it had passed an official order on the certification review. The Ministry of Information and Broadcasting had constituted an expert committee whose recommendations were accepted, leading to 6 major changes being ordered in the film. Now, these changes include a more detailed disclaimer clarifying that the film is a work of fiction and does not promote violence or defame any community. Revisions in the credits. Removal of an AI-generated scene that depicted a Saudi Arabia-style turban. Replacement of the character named Nutan Sharma. Removal of a dialogue by the same character which referenced religious texts. And deletion of a scene involving two characters, Hafiz and Makbul. The Solicitor General of India, Tushar Mehta, appearing for the centre, also told the court that any further censorship or modification beyond this would violate the filmmaker's right to freedom of speech and expression under Article 19(1)(a) of the Constitution. Taking note of the centre's order, a bench of Justices Suryakant and Joy Malya Bagchi adjourned the hearing till Thursday. The court has allowed all parties to submit objections, if any, to the centre's decision. Until then, the stay on the film release will continue. In an important update for the students, the Consortium of National Law Universities has announced that Common Law Admission Test 2026 shall be conducted on Sunday, 7th December 2025 from 2 to 4 p.m. The portal for registration for CLAT 2026 will become functional on the 1st of August until 31st October 2025, which is the last date for application for CLAT 2026. The portal for applying for the CLAT 2026 will become operational from the 1st of August till 31st October, that is the last date of application for CLAT 2026. Further details regarding the syllabus application and counselling process shall be released shortly. In a significant development today, the Supreme Court stressed the urgent need for clear guidelines to prevent investigating agencies like Enforcement Directorate from summoning lawyers for the legal advice they give to their clients. A bench led by Chief Justice of India B.R. Gavai with Justices K. Vinod Chandran and N.V. Anjaria is hearing a suo moto case in this regard. This comes after recent outrage over ED issuing summons to senior advocates Arvind Datar and Pratap Venugopal for the legal advice they gave to their clients. Following massive protest by the legal community, ED had quickly withdrawn those summons and issued a circular stating that no lawyer should be summoned without the prior approval of ED director. The suo moto case originated after a separate bench of Justices K.V. Vishwanathan and N.K. Singh objected to the Gujarat police summoning a lawyer who had simply represented an accused in a case. The judges had flagged that such actions threaten independence of legal profession and the fairness of the justice system. During today's hearing, concerns were raised that summoning lawyers like this will have a chilling effect on the justice system. One of the counsel said that lawyers will no longer feel free to advise their clients. The Chief Justice agreed, saying that even if the advice is wrong, it is still privileged communication. How can a lawyer be summoned for that? The CJI further said that there was a need to frame guidelines on the issue. Senior advocate Vikas Singh, representing the Supreme Court Bar Association, warned the court not to follow the dangerous path taken by other countries where the legal profession has been targeted and silenced. Even Attorney General R. Venkataramani agreed. On the other hand, Solicitor General Tushar Mehta suggested that a narrative was being built in the media against the Enforcement Directorate. But the bench pushed back, saying that it was based on what they see in courtrooms. CJI Gavai also pointed out how ED has been filing appeals even against well-reasoned orders just for the sake of filing them. The court clarified that the present case is not adversarial, but a protective step for independence of legal profession. The Supreme Court has now asked all lawyers involved to file detailed notes and has listed the matter for further hearing on 29th July. Stay tuned. The Apex Court today granted interim protection from arrest to actor Shreyas Talpade in multiple cases filed across different states linked to an alleged financial fraud involving a cooperative society. A bench of Justice B.V. Nagaratna and Justice K.V. Vishwanathan issued notice to the concerned parties and directed that no coercive action shall be taken against Talpade until further orders. The matter will now be heard on 29th August. Shreyas Talpade is accused of promoting Human Welfare Credit and Thrift Cooperative Society Limited, which is part of the Saga Group. Allegedly acting as its brand ambassador, Talpade's endorsement is said to have influenced people to invest in financial schemes of the society, schemes that are now being investigated as fraudulent. The actor approached the Supreme Court seeking protection from coercive action in FIRs filed in Uttar Pradesh, Uttarakhand and Haryana under serious charges like cheating, criminal breach of trust and fraud. Talpade has also requested that all FIRs be transferred and consolidated with the one filed at Gomti Nagar police station in Lucknow, which he claims is the first on record. He argues that his association with the Saga Group was limited, non-commercial and purely professional, stating that he had only attended annual events in 2018, 2019 and 2022 as a guest celebrity, which helped him gain professional exposure. Talpade maintains that he had no role in running or operations of the society and that the FIRs filed against him lack any specific allegations or material evidence. Reaffirming the constitutional right against custodial violence, the Supreme Court has ordered a CBI investigation into the alleged custodial torture of a police constable at Joint Interrogation Center in Kupwara, Jammu and Kashmir. The victim in this case is Khurshid Ahmed Chauhan, a constable in the Jammu and Kashmir Police. He approached the Supreme Court after the J&K High Court refused to quash an FIR lodged against him under Section 309 of the IPC, which deals with attempted suicide. Khurshid had been arrested and kept in illegal detention from February 20th to 26th, 2023, during which he alleged that he was subjected to inhuman and degrading torture, including mutilation of his private parts, by fellow police officers at the interrogation center in Kupwara. A bench of Justices Vikram Nath and Sandeep Mehta heard the matter. In a judgment authored by Justice Mehta, the court has set aside High Court's refusal and quashed the FIR, calling it a travesty of justice to prosecute someone who had suffered such brutality. But the court did not stop at quashing the FIR. It took serious note of the custodial torture and ordered the CBI to take over the case. The Supreme Court has directed immediate arrest of the police officers responsible for abuse and ordered that investigation be completed within 3 months from the date of FIR registration. Importantly, the court did not treat this as an isolated incident. It also asked a CBI to conduct an inquiry into systemic issues at the Joint Interrogation Center in Kupwara, raising questions about whether institutional failures or a climate of impunity had led to the brutal custodial abuse. As a step towards restitution, the court directed Union Territory of Jammu and Kashmir to pay 50 lakh compensation to the victim, calling it necessary to uphold his fundamental rights under the Constitution. The Supreme Court today rejected appeals filed by BCCI and Byju's promoter Riju Ravindran upholding NCLAT's decision that insolvency proceedings against Byjus can only be withdrawn if 90% of its creditors agree. A bench of Justices J.B. Pardiwala and R. Madhavan heard the matter. Senior advocates K.K. Venugopal and Guru Krishna Kumar appeared for Riju Ravindran, while Solicitor General Tushar Mehta represented the BCCI. The issue revolves around Think and Learn Private Limited, the parent company of Byjus, which had entered corporate insolvency resolution process after defaulting on payments to the BCCI over a jersey sponsorship deal. The insolvency process was triggered on 16th July 2024 based on a petition filed by the BCCI under Section 9 of Insolvency and Bankruptcy Code. After a settlement was reached between Byjus and the BCCI, attempts were made to withdraw the insolvency process. But here is where the legal dispute arose. BCCI and Ravindran argued that their settlement and withdrawal application, known as Form FA, was completed before the Committee of Creditors was even formed, and therefore approval from the COC was not required under Regulation 30A(1)(a). This regulation deals with the procedure for withdrawal of a corporate insolvency resolution process after the Committee of Creditors has been constituted. However, the National Company Law Appellate Tribunal and now the Supreme Court disagreed. It was noted that the COC was constituted on August 21st, 2024, but the Form FA was filed only on 14th November 2024, well after that date. Hence, as per Regulation 30A(1)(b), approval of 90% of the COC was necessary for withdrawal. Also, the Glass Trust, another creditor of Byjus, opposed the withdrawal and also objected to claim that the application had been filed on time. It pointed out that BCCI had itself asked the insolvency resolution professional to wait for the Supreme Court's decision before filing the withdrawal application. Ultimately, the Supreme Court upheld NCLAT's ruling, reinforcing that once the COC is formed, no withdrawal of insolvency proceedings can happen without its nod. This is a major blow to Byjus, BCCI and Riju Ravindran, as the insolvency proceedings will now continue unless 90% of the COC agrees to withdraw. And lastly, the top court has refused to entertain Samajwadi Party's plea challenging its eviction from its district office in Pilibhit, Uttar Pradesh. The court told the party to pursue its remedy before the civil court, where a suit for ad interim injunction is already pending. A bench of Justices Suryakant and Joymalia Bagchi made some sharp oral remarks during the hearing, questioning how the party came to occupy a municipal building for just 115 rupees. The court observed that such an allotment appeared to be a misuse of political power when the party was in government. Senior advocate Siddharth Dave, appearing for the Samajwadi Party, told the court that premises were allotted by Nagar Palika Parishad and that rent had been duly paid. But Justice Suryakant questioned, have you ever heard of a building in a municipal area being given for 115 rupees and you expect the public to have faith in this system? When the party argued that it was in possession of the building and that the municipal authorities should not have locked it, the court replied that they were now unauthorized occupants since the lease had been cancelled and that the party had not even challenged the cancellation order. Though the party claimed that the lease cancellation has been challenged, the bench was not convinced. Despite these stern observations, the court did clarify in its written order that it was not expressing any opinion on the merits of the case and that all civil remedies remain open to the Samajwadi Party. The bench emphasized that the party should seek relief from the civil court where the case is already being heard. When the party argued that lawyers' strike in the civil court was preventing them from seeking urgent relief, Justice Kant then pointed out that the Supreme Court had passed clear directions against lawyers' strikes, indirectly suggesting that this excuse was not acceptable. The court finally dismissed the petition, urging the party to pursue legal remedies before appropriate forum. Earlier in June, the top court had dismissed another plea by the Samajwadi Party challenging an Allahabad High Court order that restrained its district president in Pilibhit from filing further writ petitions over the same office eviction dispute. The High Court had made it clear that since a civil suit was already pending, the party should not misuse the writ jurisdiction.